Good morning. You're Antoine Dill.
Yes, I am.
And Mr. Dill, you were previously in court and entered pleas of true to counts 1, 2, 3, 4, 5, and 6 in a motion to revoke your unadjudicated probation. On probation for the second-degree felony offense of burglary of a habitation, placed on probation. I think the dates in this updated report are, must be wrong. It says on May 8th, 2025, he met with the high needs officer for the initial visit. Should that be May 2024?
Yes.
Okay. All right. Just want to make sure. So, placed on probation back in April of 2024 for that offense. The allegations: failure to report, failure to work, testing positive, that didn't do the theft prevention class, behind in fees, and behind in restitution. There was no agreement. Is that correct?
That's correct, yes.
Mr. And I've received an updated pre-sentence report. Has everyone had an opportunity to review that report?
Yeah, Judge.
Any additions or corrections to that report?
Nothing from the defense, Judge.
Out from the state, other than Ms. Court has any addition.
Okay.
I would like your talk.
Thank you, ma'am. Go ahead, Mr. Lewis.
Judge, this situation, from talking with my client as well as members of his family, is definitely one that his substance abuse issue is something that he definitely needs to address. He's willing to. He understands that that's, definitely been in his way as far as definitely trying to complete his probation successfully.
All right, guys. Today we're stepping inside a courtroom where a man already on felony probation finds himself standing before the judge once again. From the very start of the hearing, the situation looks serious. The court begins reviewing a long list of probation violations, including failed drug tests, misreporting appointments, unpaid fees, and classes that were never completed. As the judge examines the case, the defense attorney tries to paint a different picture. Rather than focusing solely on the violations, he argues that the defendant struggles with addiction and unresolved trauma may be the real reasons behind his repeated failures. He asks the court to see a man who needs treatment and guidance rather than punishment. Despite those arguments, the atmosphere inside the courtroom remains tense. The violations are significant, and the judge appears increasingly concerned by the defendant's history and lack of progress while on probation. As the hearing continues, it becomes clear that this may be one of the final chances the defendant has left, and the outcome is far from certain.
Or any type of conditions dealing with his probation.
He was
I know it's
high needs.
High needs. Because from talking with him, there's definitely some things he has gone through in his past that I think affect him and are triggers for him. And I believe that, if he's able to get that type of help, to help with that, I think that would definitely help with the substance abuse issue. I believe there are vehicles available through community supervision that can address that. He's more than willing to accept that help. At this point, understands he needs it. I know it looks like the recommendation in the updated PSI from probation is for ISF. It's something that they would recommend. He's more than willing to comply with that and try to work with that as much as possible. If there is anything that's available that has some type of aftercare or anything, he's more than willing to do that as well. Especially, like I was saying, as far as, any treatment he can get as far as, that would definitely help with some of the traumatic things he's gone through in his past. I think that would definitely help with the substance abuse issue going forward for him, Judge.
Okay, and the recommendation isn't necessarily ISF. It's if I were to continue, but the recommendation sounds like they've exhausted all efforts that, anyway, Ms. Smolfino?
Judge, I certainly respect all the efforts that Ms. Court has put into this defendant, and I don't ever like to overstep what the recommendation of the probation department is with respect to trying to help with probation.
In this part, the defense pushes harder, arguing that the defendant's substance abuse may be deeply connected to unresolved trauma and mental struggles from his past. His lawyer explains that probation programs and treatment options could still offer a path to recovery, suggesting that the defendant might still turn his life around if given another chance. However, the atmosphere in the courtroom begins to shift. The prosecutor calmly responds, hinting that authorities may have already exhausted every possible effort to help the defendant succeed under probation. At that moment, the tone in the courtroom changes noticeably. You can sense the judge beginning to weigh the arguments more firmly, slowly leaning toward what appears to be a final decision.
Yes, ma'am.
Yeah. I mean, sure, go ahead.
Please speak. I have made a lot of mistakes in my life. I really have. But I beg you, Your Honor, please give me another chance.
But you begged me when you were here before.
Yes, ma'am. And I got out, and the second day I was back on the streets. I did not have a plan for my life outside of just getting free. I met with the ASAP team, and they really gave me a lot of inspiration, a lot of hope so that I can change my life. Granted, Ms. Core has done an amazing job as my supervisor, and I apologize to her profusely, but I am not someone who wants to waste away in a jail cell.
Well, so here's the thing, Mr. Dill. When I looked back at your original pre-sentence report,
Yes, ma'am.
there wasn't an agreement in that case. It was a cap. And the reason for that cap is because you already have felony criminal history.
Yes, ma'am.
You've already had 2 felony probations that were both revoked.
Yes.
And then I gave you probation again because you stood there and did just what you're doing right now. You saying the words.
Please.
Stop. You need to stop because it's not going to get any better.
Yes, ma'am.
Okay?
Yes, ma'am.
By what you can say. I appreciate that you probably would like to do what you're saying,
Yes, ma'am.
but you've been given every opportunity. Probation's worked with you. Again, those felony
This is where emotions completely take over courtroom. The defendant directly begs a judge for mercy, admitting that he has made serious mistakes and insisting that he finally wants to change his life. However, the judge quickly reminds him that this is not the first time she has heard these same promises. She points out his previous revoked probations and explains that he has already been given multiple chances to correct his behavior. As the exchange continues, the tension in the courtroom grows stronger. You can hear desperation from the defendant's side, while the judge responds with disappointment and concern over the repeated failures.
she worked with you. When I'm reading through this pre-sentence report, Ms. Core tried to contact you. She tried to reschedule.
I was just texting her. I was homeless. I have been homeless a lot of my life.
But that's what probation's for, is to help you. You have to go to probation. You can't keep using those things as an excuse.
Yes, ma'am.
All right, so I'm going to find that you entered your pleas of true to counts 1 through 6 freely and voluntarily.
Yes, ma'am.
Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a habitation. Going to sentence you to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification. I need you to sign that with Mr. Lewis. It shows that this was not an agreement, so you do have some limited rights to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Lewis. I understand this isn't what you want. Take advantage of it, and when you get out, take advantage of opportunities in the community, because there are some that can help you. All right? You can go back with the...
One last thing to you, Judge. I will change my life.
I hope so. For you.
For me.
Yeah, I hope so. I really, truly do.
Here comes the moment that changes everything. After reviewing all the failed chances and violations, the judge finally delivers a sentence: 5 years in prison. Even after hearing the punishment, the defendant continues insisting that he wants to change his life. Despite the outcome, he maintains that he is ready to do better moving forward. The judge responds firmly, but not without guidance, advising him to use his time in prison as an opportunity to reflect, improve himself, and prepare for a better path once he returns to society. IT becomes one of those rare courtroom moments where accountability, regret, and reality all collide at the same time, leaving a heavy atmosphere in the room.
Mr. Boykin, in cause number 25, DCCR 0351, the state has elected to proceed on the lesser included offense of a Class A misdemeanor assault from March 5th of 2025. And how do you plead to that charge?
No contest.
Are you pleading no contest freely and voluntarily?
Yes.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed those documents on the computer, did you go over them with Mr. Parker?
It's that paper computer we went over.
Yeah.
And do you understand what you signed with him?
Not all like clear set in my mind, but
Okay. Well, do you understand that if I follow this agreement that you've made, which is for a 2-year deferred probation, that you wouldn't be able to change your mind later?
yeah.
Okay. And you understand that the agreement that you've
What
reached.
is probation?
So-
first time
It's flex.
criminal, nice as a criminal.
So,
Locked up as a criminal.
All right.
It's affected this.
right. I understand, Mr. Parker.
As I know, I was in jail and I blacked out. Then the next thing I know, I'm in the hospital.
Okay.
I go to spend
Just as one emotional case ends, another unusual courtroom moment begins. A different defendant appears confused while trying to accept a plea agreement for probation. The judge repeatedly asks whether he truly understands what he has signed, but his answers become increasingly concerning. He struggles to clearly explain his situation, raising doubts in the courtroom. He then talks about blacking out in jail and waking up in a hospital, causing everyone in the courtroom to pause at that point. It becomes clear that this case is no longer just about the charges. It shifts into a deeper concern about whether the defendant is mentally capable of understanding the legal process in front of him.
That makes sure you're doing everything you're supposed to be doing. Community.
what?
Not in trouble.
In trouble for what?
So here's what I'm going to do. I'm going to reset the case. Mr. Boykin, I'm going to have a doctor come visit with you to make sure you understand everything that's going on before we go forward, okay? So when they come out to the jail or visit with you online, you need to make sure and visit with them, answer all their questions.
Sit in jail?
Yes, sir. I got to make sure.
Jesus Christ, no.
I got to make sure you understand everything
No,
that's going
my
on.
first time blacking out like that. I was in jail and I
Okay.
didn't get fed. I was naked
Okay.
and I blacked out.
We're going to go back with the
That's my
bailiff.
first time I was doing anything like this.
We're going to make sure you can go back with the bailiff. Go ahead.
Oh. Yeah. I do have.
I'm going to delete that paperwork.
I don't know. I mean, it's weird because you can talk to them and they'll be fine, and then he
I know.
does that, and then I'm like, look, keep on going. Like,
The confusion grows even deeper in this section as the court attempts to explain the requirements of probation. The defendant struggles to follow along and continues speaking about strange experiences he claims to have had while in jail. As the situation develops, the judge ultimately decides to stop the plea process entirely. A medical evaluation is ordered before the case can move forward. IT becomes a tense but important moment in the courtroom, as it is clear that rushing proceedings could be unfair if the defendant does not fully understand what is happening around him.
CR 0278 charged with assault of hospital personnel, and Miss Bailey was evaluated for competency to stand trial by Dr. Capon. I received that report dated April 22nd of 2025. Dr. Capon makes the finding in each of these cases that Miss Bailey is currently not competent to stand trial and that inpatient treatment for competency restoration is warranted. Is there any other evidence with regard to competency, Mr. Parker?
no, Your Honor.
Mr. Nichols?
No, Your Honor.
Then at this time, based on that report, I am going to find Miss Bailey not competent to stand trial, order that inpatient treatment for competency restoration be provided at the appropriate facility, and that at that facility for a period of not to exceed 120 days from the date Miss Bailey gets there, and we will await to hear if she has been restored at the end of that 120 days. You can go back with the bailiff, ma'am.
120 days?
Well, they're going to send you to a hospital to get you some help to make sure you understand everything better. And so cooperate with everything they want you to do, and we'll get you back here and get your cases taken care of, okay?
So I'm going to a hospital, then back to jail?
Yes, ma'am.
120 days at the hospital?
Well, it depends if you do what they say at the hospital and follow all the instructions, medication, whatever it is, so that you have a better understanding of everything that's going on. Okay?
I don't need medicine to understand.
You can go back with the bailiff.
I don't get it. Why y'all taking me to the hospital, then back to jail?
The final part introduces another defendant whose competency evaluation has already been completed by doctors. The judge officially rules that she is not mentally competent to stand trial and orders her to undergo treatment at a hospital for up to 120 days. What makes this moment powerful is that the defendant still appears confused about why she is being sent away. The seriousness of the ruling does not seem to fully register with her in the moment. The courtroom ends on an emotional and uncomfortable note as reality slowly sets in. The situation leaves a heavy impression as the proceedings come to a close.